People versus Galano, GR number L-42925, January 31, 1977. This is for criminal procedure, specifically Section 2 of Act number 3326. Section 2 of Act number 3326 provides that prescription shall begin to run from the day of the commission of the violation of the law, and if the same be not known at the time, from the discovery thereof and the institution of judicial proceedings for its investigation and punishment. The prescription shall be interrupted when proceedings are instituted against the guilty person, and shall begin to run again until the proceedings are dismissed for reasons not constituting jeopardy. Facts of the case. This case was about the dismissal of the charge for estafa due to the misapplication of the rule on interruption of the running of the prescriptive period of crimes in connection with the trial court's lack of territorial jurisdiction. Juanito Limbo, the private complainant, filed a criminal complaint for estafa against Gregorio Santos, the respondent accused, for the latter's failure to account the sum of money representing the net proceeds of sweepstakes tickets that had been entrusted to him by the private complainant. The alleged offense was committed on or about September 16, 1962, and private complainant filed the said complaint in the Municipal Court of Batangas on October 2, 1962, which was within the 10-year prescriptive period of the criminal complaint. Respondent accused, upon arrest, posted a bail bond for his provisional liberty. He was thereafter arraigned and he pleaded not guilty to the charge. The case was heard on its merits. However, on September 16, 1964, the accused jumped bail. As a result, his bail bond was forfeited and the case against him was archived by the Municipal Court of Batangas. It was not until September 14, 1973, or about 9 years later, when the accused was rearrested and the trial court of the said case resumed. On October 21, 1974, while the said case was pending trial, respondent accused filed a motion to dismiss the case on the ground that the Batangas court did not have territorial jurisdiction over the case, since the evidence showed that the crime was committed in Manila. The Batangas City Court issued an order dated November 5, 1974, dismissing the case for lack of territorial jurisdiction over the crime charged. On November 14, 1974, the private complainant refiled the same case against respondent accused in the Fiscal's Office of Manila. A preliminary investigation was conducted, and on July 29, 1975, the corresponding information was filed with the Court of First Instance of Manila. On November 12, 1975, the respondent accused filed a motion to dismiss the case before the Court of First Instance of Manila on grounds of prescription and double jeopardy. The prosecuting fiscal opposed the said motion. However, the respondent judge granted the motion to dismiss on the ground that the offense charged had already prescribed. The respondent judge, Honorable Ricardo D. Galano, held that there had been no valid complaint filed with a competent court since Batangas court lacked territorial jurisdiction over the offense charged. Hence, there was no interruption of the prescriptive period during the pendency of the case in the said court. The motion for reconsideration filed by the prosecution was likewise denied. On appeal by certiorari, the petitioner, People of the Philippines, argued that the respondent judge gravely erred in dismissing the case despite the provisions of Article 91 of the Revised Penal Code, which clearly indicate that the offense charged has not prescribed, and in not considering the prevailing jurisprudence indicating non prescription of the offense charged. Issues: first, whether the respondent judge correctly ruled in holding that the offense charged had already prescribed on the ground that there was no interruption the prescriptive period. Second, whether the respondent judge correctly ruled in holding that there was no interruption of the prescriptive period because Batangas court has no territorial jurisdiction of the offense charged. Ruling, the Supreme Court said no. The respondent judge did not correctly rule in holding that the offense charged had already prescribed on the ground that there was no interruption of the prescriptive period. Article 91 of the Revised Penal Code provides that the period of prescription shall commence to run from the day on which the crime is discovered by the offended party, the authorities, or by their agents, and shall be interrupted by the filing of the complaint or information, and shall commence to run again when the proceedings terminate without the accused being convicted or acquitted, or are unjustifiably stopped for any reason not imputable to him. In this case, the respondent accused, after his plea of not guilty and during the trial, jumped bail in September 1964 and evaded rearrest for 9 years until September 1973 when the trial was resumed. Thus, when Batangas Court, in its order of November 1974, dismissed the complaint for lack of jurisdiction, the proceedings therein terminated without conviction or acquittal of respondent accused, and it was only then that the prescriptive period, which was interrupted during the pendency of the case in the Batangas Court, commenced to run again. Hence, when the City Fiscal of Manila, upon complainant's instance, refiled on July 1975 the same case against respondent accused in Manila Court of First Instance, after having conducted a preliminary investigation, it is clear that not even a year of the 10-year prescriptive period had been consumed. Therefore, the respondent judge did not correctly rule in holding that the offense charged had already prescribed on the ground that there was no interruption of the prescriptive period. As to the second issue, the Supreme Court likewise said no. The respondent judge did not correctly rule in holding that there was no interruption of the prescriptive period because Batangas Court has no territorial jurisdiction of the offense charged. Settled is the rule that the jurisdiction of a court is determined in criminal cases by the allegations of the complaint or information and not by the result of proof. In this case, the Batangas court was vested with lawful jurisdiction over the criminal complaint filed with it which expressly alleged that the offense was committed in the municipality of Batangas, province of Batangas. Thus, the proceedings therein were valid and before a competent court, including the arrest warrant, the grant of bail, and forfeiture thereof upon the accused's jumping of bail. Until the same court issued its November 1974 order dismissing the case and declaring itself without territorial jurisdiction on the basis of the evidence presented to it by both prosecution and the accused. It follows just as clearly that the prescriptive period was interrupted and told during the 12-year pendency of the proceedings before the Batangas court for 9 years, of which respondent accused had jumped bail and evaded rearrest. The true doctrine is and should be the one established by the decision holding that the filing of the complaint in the municipal court, even if it be merely for purposes of preliminary examination or investigation, should and does interrupt the period of prescription of the criminal responsibility, even if the court where the complaint or information is filed cannot try the case on its merits. Therefore, the respondent judge did not correctly rule in holding that there was no interruption of the prescriptive period because Batangas court has no territorial jurisdiction of the offense charged. In applying the foregoing, the respondent judge dismissal orders were set aside and the case was remanded to the Manila Court of First Instance for continuation of the trial.